Now let's talk about the regulation of advertising and marketing communication. Government regulation is costly and onerous to an industry, so industries often try to preempt potential government regulation by adopting their own regulations first. Advertising also adopted self-regulation. Starting in the late 1960s and early 70s, consumerism, which was another name for the consumer protection movement, was growing strong. Due to this pressure, legislators and regulators were becoming concerned with consumer protection. So to head off incipient government regulation, the advertising industry formed its own regulatory body and began to crack down on areas of gravest concern to the consumerist movement. The National Advertising Review Council is the advertising industry's self-regulation program. It was started in 1971 by the major advertising trade associations, the American Association of Advertising Agencies, the American Advertising Federation, the Association of National Advertising, and the Council of Better Business Bureaus, or the CBBB. The Direct Marketing Association, the DMA, and the Electronic Retailing Association, and the Interactive Advertising Bureau were added to its board of directors in 2009. This board sets policies and procedures for the advertising industry's self-regulation. The National Advertising Review Council has 3 investigative units and an appellate court. The Council of Better Business Bureau's National Advertising Division investigates and makes recommendations regarding marketing communication complaints. The Council of Better Business Bureaus is the national umbrella organization for the North American system of Better Business Bureaus, and it's an outlet for consumer complaints as well as company complaints against their competitors. Founded in 1974, the Children's Advertising Review Unit promotes responsible children's advertising by evaluating child-directed advertising and promotional materials in all media to advance truthfulness, accuracy, and consistency with its self-regulatory guidelines for children's advertising and relevant laws. The Children's Advertising Review Unit is a special unit of the National Advertising Division. The National Advertising Review Council developed its electronic retailing self-regulation program at the Electronic Retailing Association's request in 2004. The Electronic Retailing Self-Regulation Program focuses on self-regulation of direct response advertising and provides a quick and efficient mechanism for review of high-profile direct response advertising, such as before and after photos and weight loss advertising. The direct response industry includes any marketing communication that has a direct link to the marketer, such as a telephone number, email address, mailing address, or website. Other examples include infomercials or banner advertising. And then finally, the National Advertising Review Board is the appeals court. If the offending firm fails to heed the National Advertising Division's recommendations, then the National Advertising Review Board makes its own ruling. And then, if the National Advertising Review Board ruling is ignored, the matter is turned over to the FTC. Marketing to children is a major concern to regulators and consumer groups. One major reason for this concern is evidence based on Piaget's theory of cognitive development that children are not able to fully comprehend commercial messages. Now, comprehension here has 2 dimensions. The first is that children often don't understand the persuasive intent of commercials. That is, commercials and other types of advertising and marketing communication have the intent that they're trying to sell you something or convince you to take some action. The second is that children often don't comprehend specific words and phrases. Another reason for concern over marketing to children is the potential effect it has on their safety and value. The Children's Advertising Review Unit has specific voluntary guidelines by which it evaluates advertisements targeted at children. So in addition to self-regulation, there is government regulation. Now, the First Amendment of the U.S. Constitution guarantees freedom of speech. The First Amendment to the U.S. Constitution grants everyone the right of free speech and protects all forms of communication, including advertising or commercial speech. Most commercial speech is protected by the First Amendment, except when it is deceptive, unfair, involves an illegal product, or conflicts with a substantial government interest in restricting the speech. Then regulation to advance the government's interest is allowed, but it must be narrowly confined to that interest, such as national security or children's health. The Constitution also gives the federal government the power and responsibility to regulate interstate commerce. Further, most state constitutions grant the state the power and responsibility to regulate commerce conducted entirely within its borders. In addition, the Federal Trade Commission, FTC Act, was designed to protect fair trade practices among firms, but expanded in 1938 to prohibit false advertising as a form of unfair and deceptive commerce, and allows the FTC to enforce laws regarding marketing communication. If a message to a consumer differs from the product in a material way that leaves the typical consumer with a false impression, it is judged as deceptive. Facts in marketing communication must be substantiated. The Lanham Act allows private parties to bring lawsuits against advertisers. The Federal Communications Commission, or FCC, regulates licenses and behavior of radio and television stations and telephone and cell phone service operators. The FCC also enforces the Children's Television Act, which limits the amount of advertising on TV aimed at children. The Food and Drug Administration, or FDA, oversees accurate labeling and packaging and regulates direct-to-consumer advertising of pharmaceuticals. Some of the FTC's main concerns include deception, comparisons, endorsements, demonstration, and bait and switch advertising. Advertisements are false if they are, first of all, untrue. For example, Listerine used to claim that it was a remedy for colds and sore throat. This is not true, so that is obviously false advertising. Another example, Crestor said the FDA had determined that the medication poses no safety concerns. Also untrue. Therefore, that is obviously false advertising. But false advertising can also be advertisements that make representations that the advertiser has no reasonable basis to believe, even if the representation does turn out to be true. In other words, research must already be available to support any claims before you make that claim. For example, if you say a natural bicep enhancement supplement will double the size of most men's biceps, but you have no research to support that, then you're generating false advertising, even if the statement is true. Third, advertisements can be misleading, even if they are true. For example, an Anacin ad said that Anacin was as effective as aspirin, when in fact, Anacin is aspirin. The statement it made was true because it was as effective as what it was, but the implication was misleading. Now, to establish a violation under the Lanham Act, a consumer group or competitors must prove the following. First, the advertiser made false statements of fact about its product. Second, the false advertisements actually deceived or had the capacity to deceive a substantial segment of the target population. Third, that the deception was material. And fourth, the falsely advertised product was sold in interstate commerce. And fifth, the party bringing the lawsuit, known as the plaintiff, was injured as a result of the deception. Note, actual loss is not required to show an injury. All that is needed is a reasonable basis for the belief that the plaintiff is likely to have been damaged as a result of the advertising. Because of the Lanham Act, companies keep a sharp eye out for false advertising from their competitors because it's an easy way to knock out the competition. As a result, the advertising field has a high degree of self-regulation. Now, what is bait and switch advertising? Well, bait and switch advertising occurs when the advertised good or service is withdrawn from the market and substitute goods or services are offered instead. With privacy issues, the FTC has been hesitant to craft specific legislation. However, in response to the rapidly changing online environment and in response to the increased use of covert behavioral tracking and targeting of consumers online, the FTC did put forth a framework and guidelines that deal with designing privacy into organizations, simplifying consumer choice in the area of privacy, and offering greater transparency and simplicity to privacy practices and statements. A major aspect of privacy relates to consumers' choice of whether or not to have their online searching and browsing behavior tracked. So the FTC has been very supportive of a do not track approach to this issue, which would allow consumers to opt out if they wish. Both industry self-regulation and government regulation of marketing communication share similar goals and concerns. As I've said, for an advertisement to be deceptive, the representation, omission, or practice must likely mislead reasonable consumers. Practices that have been found to be misleading or deceptive in specific cases include false oral or written representations, misleading price claims, sales of hazardous or systemically defective products or services without adequate disclosure, failure to disclose information regarding pyramid sales, use of bait and switch techniques, failure to perform promised services, and failure to meet warranty obligations. Deception is examined from the perspective of a consumer acting reasonably in the circumstances. If the representation or practice affects or is directed primarily to a particular group, then the FTC is supposed to examine the reasonableness from the perspective of that group. Another is the protection of vulnerable population. This includes children. Television is an important source of information for children about products. Children between the ages of 2 and 11 watch an average of 21 and a half hours of TV per week. And that could be television on broadcast or cable, but also television online or on demand. Children also are exposed to about 22,000 commercials or advertisements per year. Children are vulnerable because they're not fully developed in their cognitive abilities and defenses. Another area of concern is advertising to minorities. While targeting members of minority groups should be encouraged to allow them to have greater access to products and to provide greater efficiencies to marketers, doing so sometimes has a sinister connotation, and it has an even worse connotation if the products are potentially harmful.